everyone. Welcome to Crime in Court. This is the 1996 Menendez brothers retrial. We are reading through the transcript of California versus Erik and Lyle Menendez on trial for the second time for the homicides of their parents, Kitty and Jose. First trial ended in a mistrial, and now we continue where we left off. We are on the state's case, part 39. We are very close to the end of their case. This is their last big witness. They will also recall Detective Les Zoller, who was the lead investigator, very briefly, but this is their last witness. So we are going to pick up right where we left off. They went to lunch. There was about an hour's worth of cross examination starting, well, in the last stream, I should say. The cross examination by Lyle's team began. He uh, questioned him for about an hour. Then they went to lunch, and now that's where we are picking up. All right. So again, this is Tuesday, November 14th, 1995, and the court says, "Okay, everybody is present. We will have the jury out, please." The jury enters the courtroom, and the following proceedings were held. The court says everyone is back and we will resume with cross-examination. Mr. Gessler says, "Thank you, Your Honor, Mr. Gessler, for." Oh, let me shrink myself here. Sorry about that. So Mr. Gessler is for the for Lyle's team for the defense. He says, "Dr. McCarthy, the Divender Grewal, did I pronounce that right? Yes, I think so. That you worked with. He is the gentleman with the black beard in the second row here." "Sure. Stand up." He tells the dude to stand up. Oh my God. I hate witnesses like that think that they just control the courtroom. But whatever. So Mr. Gessler says, and he received his master's degree from Stanford in 1994. Yes. And he is not one of the doctors that you have on your staff there, the 70 to 90 PhDs? Not yet. And his degree, that's mechanical engineering, isn't it? Biomechanics. I went through a whole thing in one of my streams, the difference between biomechanics and mechanical engineering. Basically, mechanical engineer deals with machines and how physics affect machinery, engines, things like that. A biomechanical engineer looks at how physics and uh, those kinds of things, physics and science, how it affects human bodies. So that would be, injuries. There was the biomechanical engineer for the Karen Reed case was Dr. Rentschler, and he spoke to all of the injuries that he would have seen if Karen had hit him with her car, which she didn't. So his injuries were inconsistent. So that's what a biomechanical engineer is for, is talking about how objects and inanimate objects can interact with the human body, or how the human body can, fall and things like that. So that it's a very big difference than a mechanical engineer who deals with machines and how things work and stuff like that. So, anyways, Mr. Gessler says, well, mechanical engineering is the degree that was awarded for the master's, isn't it? Yes. His specialty in mechanical engineering was biomechanics. But my question is, the degree that was awarded was mechanical engineer, correct? Yes. Now, you brought the targets. Yes. Let's go through the targets. May I approach the witness, Your Honor? The court says yes. Okay, so the targets, just in case you don't remember from the last stream, this witness did some target shooting and from different distances. I believe it was 6 and 12 feet. And he determined, the spread of the pellets, the ammunition when it came out of the gun. What was the spread of that ammunition? So he did tests on that. That's what the targets are from. He didn't have them in the last hour. that he was on the stand. So this is for he brought them back in, or he obtained them during the break and got them, and now they're going to go over the targets. So Mr. Gessler says, "Let's go through the targets. May I approach the witness, Your Honor?" The court says, "Yes." Okay. Mr. Gessler says, "Okay, why don't you hold on to them? These are the targets that you shot with the Mossberg." "Yes." "And first, can you show us the ones that you shot at 6 feet?" "I can. These." "Okay, you have one, two, three, four targets?" "There's another one, five." "All right, five. Yes. Yes, that's correct." "So one of these says that it was a Winchester." "Right. That's not the Fiachi that you shot then, is it?" "That is correct. It's not a Fiachi, it is a Winchester." "Well, wouldn't you try shooting Fiachi so you could find out if the same ammunition provided target scatter that was useful to you?" "If the same ammunition was used, and that was precisely why I shot a controlled Winchester." "Well, Winchester doesn't help you know what the Fiachi did, does it?" "No, but it does help you determine if I was trying to understand if there was a significant ammunition to ammunition scatter, so I was just shooting the same thing." "What?" "This one is a Winchester also, isn't it?" "Correct." "So that leaves three that you shot with Fiachi?" "Yes." "And where's the other three you shot with Fiachi at 6 feet?" "These are the only ones I've got." "Did I shoot three others?" "Well, you told us that you shot six from 6 feet with Fiachi, so that's what I'm asking you." "Okay, I shot five, but I guess I didn't understand the Fiachi conjunction. I only had three. I don't recollect shooting six with Fiachi at 6 feet." "Well, didn't you tell us this morning that you could have shot more Fiachi out of that 200 box and come up with a better pattern, perhaps?" "I wouldn't come up with a better pattern, but I would have come up with a wider distribution. But yes, I could have shot dozens." "But instead of dozens, you shot three with Fiachi." "That's correct." "Let's take that one you shot with Fiachi. What was the scatter pattern on that one?" Miss Abramson said, "Is there some way you could mark these or identify them?" The court says that's up to counsel if you want to mark them. Mr. Gessler says we can mark them. May I know what the next exhibit in order is, Your Honor? The court says 278. Let's mark the first range as 278. Ms. Towery says 279, Your Honor. 279, says Ms. Nahara. The court says, what is 278? Ms. Nahara says, a final sketch of the triangle. Ms. Abramson says, may I approach, Your Honor, to mark my copies? Court says, yes, you may do so. Mr. Gessler says, and what is the diameter of your pattern on that one? 279. The shot, which I believe in this down here, the other two holes are plastic, ballpark, an inch. Well, how about better than ballpark? Don't you have a little better measuring device? I didn't bring it in. Do you have a caliper there? We have a caliper upstairs, sorry. Mr. Levin for Eric's team says, I have a ruler if that will help. Mr. Gessler says, that'll be fine. Mr. Levin says, I think it's calibrated. The witness says, it probably isn't, but that's all right. Now, what dimension would you like me to measure on that pattern? Mr. Gessler says, oh, you might try the widest diameter. Okay, inch and 3/16, inch and a quarter. Inch and a quarter? Now, let's mark the next one 280. Inch and 5/16. Okay, and let's mark this one 281. 2 inches. And does that one appear that the wad went through that one also? It appears so. That could be a wadding mark there. And you are looking at the back of Exhibit 281? Yeah, if I had to do a pellet, I'd capture that gray there, but the pellet to pellet gray is still 2 inches. So you have 1 and 3/16 inches, 1 and 5/16 inches, and 2 inches from 6 feet. Yes. And those three are the only targets that you shot from 6 feet with Fiachi ammunition. Correct. Now, how about the six that you did at 12 feet? 5 in Fiachi. 5 in Fiachi from 12 feet? Yes. All right. Let's take, may we mark the first one 282, Your Honor? The court says yes. Mr. Gessler says, would you tell us the scatter pattern on that one, the same that you did on this? Would you tell us the scattered pattern on that one, the same, the way that you did the 6 feet? I don't know what that means. I am uncomfortable, or I am comfortable that we might be a wad, that might be a wad. I am comfortable that that might be a wad. So I don't know. I don't understand Mr. Gessler's question because I think there might be some errors in it, the way that it was typed up. How about the part that's probably not a wad then? 2 3/4. All right. Yeah, 2 3/4. Now that's not counting what's at the very top that you think might be a wad. Yeah, if you do that with a wad, it becomes 3 and 3 1/2. Okay, let me mark the next one, the next in order, Your Honor. Court says 283. The witness says, I should be putting stickers on these, or someone's going to have to. Ms. Abramson says, I'm marking copies. The witness says, okay, thank you. 2 7/8. Mr. Gessler says, next one in order, please, Your Honor. The court says, well, it's not very helpful. Ms. Abramson says you're marking copies, and there is no way to verifying copy versus the original unless there's something on the record. So, Dr. McCarthy is correct. We should be labeling these originals, not copies. Mr. Gessler says we can label these with stick-ons. We can accomplish that, Your Honor. The court says, okay, 284. The witness says 3 inches. Mr. Gessler says, now, do you want to put it down here where it doesn't cover that scatter pattern? Now, what did you get? 3 inches. 3 inches on 284? Mm-hmm. And the next one we will mark 285 as soon as we get a stick on here. That's another 12-foot shot with Fiachi. Yes. Ballpark 2 1/2. 2 1/2 inches? Yes. And finally, 286. This is also 12 feet. 2 1/4. Dr. McCarthy, where are the ones that are 5 inches? These that's 5 inches. Is that a Fiachi? No, it's a Western. Well, Western? Again, that's not Winchester either. It's Western. Excuse me, Winchester. I'm sorry. Does it say what it is? Yeah, Winchester number 4. None of the Fiachi were 5 inches? That's correct. So the spread from the Fiachi was a lot less or, more condensed than the Winchester. The Winchester ammunition has much more spread. And then you were in error when you told Mr. Khan and Ms. Nahara and I that it was 5-inch pattern on the Fiachi. I don't recollect tying the pattern specifically to Fiachi, but if I was recalling the Winchester pattern when I was talking about Fiachi, yeah, I just had the wrong ammo pattern in mind. So he admits he was wrong, but he says if I was recalling the Winchester pattern, then I was wrong. So the Winchester pattern was only one shot at 5 inches, wasn't it? I don't understand your question. You mean at the spread? Yes. Well, I mean the Winchester tended to scatter more, but here again, and I sort of said 5-ish. There is 5 inches, Word salad. That was like a bunch of what? Well, yes. There's 5 inches on one Winchester. Is that what you're saying? 2 Winchesters. But not on any of the Fiachis. That's correct. And the Fiachis is what you were interested in for this case. Well, I was interested in all of them, but the Fiachi was the primary benchmark I was looking at. Yes. That's what this case was involving was the Fiachi, wasn't it? That has been the testimony. I have not independently come to a conclusion on that. So you haven't come to a conclusion independently that Fiachi ammunition was used. That's correct. What is your opinion as to what was used? I don't have an opinion. It's just that I was unable to find, after looking at a number of gun shows, exactly the same internal construction as the ammo that was used in this case. I purchased Fiachi exemplars and used those, but I haven't formed an independent conclusion as to the ammunition used in this case. You didn't go out in 1989 trying to find a Fiachi ammunition? Well, no, I wasn't involved in this matter in 1989. But when you go to gun shows, you can buy old ammunition, and I have attempted to buy old Fiachi, and I have gotten older versions of double-aught buck, but I haven't found number 4. Did you consult with the criminalists who worked on the case in this first trial? I met with Mr. Zoller, so Detective Zoller. Um, so they're saying he didn't use the exact same ammunition. This is a really good point by Lyle's defense team, is that they used ammunition from earlier models, like more recent productions of that ammunition, as opposed to the ammunition that was manufactured and sold in 1989, which would have been the ammunition that they were using. So there may be a difference in the manufacturing, how the spread goes and whatnot. So that was a really good point, I thought, by him. So he says he met with Detective Zoller. Well, Detective Zoller is he says Mr. Zoller. And then Mr. Gessler says, well, Detective Zoller is a detective, isn't he? But I don't know whether he fits your definition of a criminalist or not. No, a criminalist in the definition is somebody who works with evidence at the scene, ballistics, ammunition, guns, things of that nature. Did you talk to Deputy Van Horn of the Sheriff's Department? I don't recollect doing so. Or to Chuck Morton. He is a criminalist up your way, isn't he? I don't know Mr. Morton. So you didn't check with any criminalist then to try to look at the old ammunition from the case and see if you could find out what it was? I have just been accepting its Fiachi. I haven't attempted. No one has asked me to form an independent opinion. Well, you have no reason to believe that it's not Fiachi, do you? No. And you said that you looked at the exhibits in this case from the first trial? Yes. You looked at the pellets that were recovered, didn't you? Yes. Determined they were number 4 buck? Yes. Looked at one of the shot cups that was recovered? Yes. Looked at the waddings that were recovered? Yes. And you know that the analyst at the first trial determined that it was Fiachi. Mr. Khan says objection, calls for hearsay, sustained. Did you read the testimony of any of the criminalists who testified at the first trial? Yes. And did you understand from reading their testimony that it was Fiachi ammunition that was used? Objection, calls for hearsay, overruled. You may answer the question. The witness says, that's what I recall the testimony was. Mr. Gessler says, that is your recollection? Yes. Now, Dr. McCarthy, you listened to the tape recording of our conversation over the lunch hour, didn't you? I read the transcript. I didn't have time to listen to the tape. The tape was about 45 minutes, wasn't it? Understood, but I read the transcript. It was faster, and I do have a job, and I try to do it during the lunch hour. In other words, you didn't listen to the tape, you read the transcript. That's correct. Well, did you say in that conversation that as to the leg wound on Jose Menendez, that if it was the court says perhaps you can just point to the page. He has the transcript right there too, Mr. Gessler. Page 30 of the transcript of that telephone call, down about 2/3 of the way, if I could, Your Honor, right there where it says WK for Walter Kristula. I'll see if I can recover that. I am sure we can. Okay. Question by Dr. Kristula, or however you say that. All right. And did you make any conclusions of roughly how far the person would have been from the leg shot? Roger McCarthy says, close, but I haven't. Once again, if that became relevant, I could scale the wounds of the autopsy and go to my shot patterns and make an estimate. Just nothing in my reconstruction has required that, so I haven't done it. Is that what you said in that phone conversation? Looks like it. So these reconstructions of shot patterns, they were just relevant to your determination of these shot sequences. No, I just couldn't make an estimate that would be defensible if by the time we got done with the distributions on these shots. You couldn't make an estimate that would be defensible? That's not the answer you gave to the question, though, is it? Well, you asked a different question now. The question was, did you make any calculations? And your answer was, if it became relevant, you could. Isn't that it? That's right, I could, but I couldn't defend it. I would be cross examined to death on it. And now you're being cross examined to death for not doing it, right? Did you scale the scatter pattern for what you call shot number one? That is, the shot that you say went through Jose Menendez's left elbow, hit his right elbow and shoulder area, and lodged in Mrs. Menendez's left breast. Did you scale that to see how wide a scattered pattern that would be? No, there would be no way to do, or to, there would be no way to. I am just asking, did you or did you not? I did not, could not. Mr. Gessler says, I have no further questions, Your Honor. I think Miss Abramson might have a few, though. The court says, okay. Ms. Abramson says, I want to get the targets straightened out if we can, Your Honor, first. The court says that would be good. Ms. Abramson says, just to make sure, and let me start with a question. So we're about to start cross-examination from from Eric Menendez's team. Ms. Abramson asks, Dr. McCarthy, you provided copies of these targets to counsel in this case, both prosecution and the defense, is that right? Yes. Are the images on the copies, however, the reverse of the images on the actual targets? No, but they're only an image of one side of the target. In other words, yeah, well, I am just talking about whether they line up with the side of the targets that got printing on it or whether it's the other side of the target. Different question. Line 279, okay, 279 lines up the way we are now holding it, but the side of 279 that has the writing on it, basically the flip side. Yeah, I wrote on the back of the target. That is the exit. Excuse me. So on our copies, you are writing on the front? No, no. Did I put that on? I guess that's how they came to us. Okay, good. All right. This is 279 though, right? They transferred the information from the back to the front of the target for you. And I wrote on the back. So now this is the label for 279 until the clerk does a better one. Why don't you put that aside? And this is the one I wrote 280 on the back as you were marking it, okay? And that's therefore, why don't you turn it over so the clerk knows which is the back and put the label on the back. And this is the one I wrote 281 on, right? So let's stick a 281 on that. And this is the one I wrote 282 on. Yeah, flip it over, that's 282. And this is the one I wrote 283 on. It's a 12-foot. It's that one. I already stuck one on there. I know I didn't do it on all of them, okay? And this is the one that we labeled 284. That's it. And that's already got a label on it. Good. Now, could you find the one that I wrote 285 on? Here it is. Okay. And 285 is this one, right? Oops, slippery little devils. Must have slipped out of her hand. Sorry about that, he says. So now I've got my 285 marked, and the last one, which has this is a wad impression, this hole, isn't it? Yes. And that's 286. Okay, so now we've got them all. And the others, the Winchesters, were not marked. Is that correct? You mean just now? Right. Yes, I don't think so. I think maybe we should do that just for the future reference. Okay, so we finished with 286, Your Honor. Let's just move on and mark. You have some 6-foot Winchesters, I think you said. I have one 6-foot Winchester. Why don't we mark that one 287? And then you had two 12-foots. Mm-hmm. Okay, we will mark one of them 288 and one of them 289. Good, that's done. Let's see now. I have one for two questions. I have one or two questions, sorry, Your Honor. Dr. McCarthy, have you ever testified in a criminal case before? No. And are you aware of the fact that you are participating for the prosecution in this case has been written about in publications? Not by me, but yes, there has been some writing about it. So some publicity for your firm, correct? The firm has been mentioned. In Time magazine, for example. Oh, are you aware of that article? There was some mention in Time, but my recollection is it was only quoting you. I'm not sure there would have been independent mention, but maybe there would have been. I don't know. Quoting me talking about your firm? Yes. And there was a write-up in the Los Angeles Times about your work in this case. There have been a couple articles in the Los Angeles Times, yes. And were there articles in USA Today and other nationwide publications about your participation in this case? I am unaware of anything in USA Today. Well, what are you aware of? The Los Angeles paper and the Time magazine. Now, there have been a number of articles, some of some length, written about failure analysis over the years, have there not? Oh, yes. And you are a person frequently quoted in magazine and newspaper articles when the subject matter of accidents or such as the Exxon Valdez or the Hyatt walkway collapsed. When those kinds of engineering disasters are mentioned, you are often quoted. Is that correct? And that's probably a little too kind. I am quoted on occasion. Well, isn't one of the ways in which failure analysis gets the word out to those Fortune 50 companies who can afford you is through frequent reference in the press? I feel like I'm speaking tongue twisters. No. We run numerous correlations. In fact, we even tried an advertising experiment once. It doesn't do anything to our business. Okay. So it was an advertising experience where you had an artist commission works of art, like linking your firm to, or rather suggesting that perhaps if Icarus had hired your firm, the wings wouldn't have melted. That sort of thing. No, we could have reconstructed the crash, but you've got the fundamental thing. So you come along after the disaster, right? Most often, yes. When you testify, you have an independent testing laboratory. That means it is not directly owned by a manufacturing company whose products you test, correct? That's what you mean by independent. Yes, we are independent of any product manufacturer. So until they hire you, at which point you're working for them, correct? We are consultants to them. And you get paid like $600 an hour to do tests, for example, on GM cars or trucks that are involved in either litigation or investigation by the federal safety folk. Isn't that what you do? So then why is he testifying in this case as an expert? That makes absolutely no sense. His answer is, or product development. I am involved in the testing of a vehicle that would be my billing rate. So he agrees, $600 is his billing rate. Um, so he tests cars and works on product development. He's the CEO, right? Or something along those lines of this company. And uh, I don't see what his expertise is in relations to what he's testifying about. I'm very confused. Ms. Abramson goes on and says, but my question was, isn't it true that even as recently as July of this year, at least 50% of the work of failure analysis was for the major auto manufacturers? I would estimate ballpark 50%. Yes, I couldn't prove that number to you. Wouldn't you know where most of your business comes from? Especially if you're the CEO. Those are things you should know. But that's what you testified to in a case in St. Louis in July, correct? I don't recollect specifically doing so, but the number is correct. About one half of all violent premature death is automotive related, and about half of our work is automotive related. Then why did you just say that it wasn't? Or that you couldn't tell us that? See what I mean about this guy? Like, he's just off. There's something off about him. And when automotive related on the side of the auto manufacturers, correct? Overwhelmingly, yes. Well, how many times have you ever testified on behalf of a person, living or dead, who was injured in an automobile accident who was suing an automaker? On 2 or 3 occasions. Are you sure it wasn't just one, as you testified in St. Louis? Well, it was Kaplan versus Toyota and Garcia versus Ken Tool. And Ken Tool is an auto manufacturer? They're an automotive component part manufacturer. They make parts for the automotive industry. And when did you testify in the Kaplan case? It was a while ago. 10 years or more? Ballpark. And what about Garcia? That is also 10 or 15 years ago? No, like 6 or 7 years ago. That's it? That's all I can recollect as I sit here. And how many times have you testified? Let's just start with one. How many times have you testified in the past for General Motors? I wouldn't have a specific recollection, but could be ballpark 2 dozen. And how many times have you testified? Did you ever testify for Ford? Objection, irrelevant, overruled. Yes, I have testified in cases on behalf of Ford Motor Company. How many times? I couldn't estimate accurately, a couple dozen. More than GM or about the same? I would suspect probably more, but it's tough to look back over your whole career and come up with that number. And you have been testifying for the automakers over a long span of your career, correct? Oh, yeah. We have been an automotive tester for a long time. And you have testified on behalf of Suzuki, correct? Yes. And that was who you were testifying on behalf of this past summer in St. Louis? Yes. Now, isn't it true that GM no longer employs you? I'm sorry? Is GM still employing you personally as an expert witness in their cases? Well, they were when I left the office. In 1992, wasn't there a scandal involving GM and federal government based on some figures that you submitted that were fallacious? Quite the contrary. The government eventually agreed that they were correct and dropped the action. I'd be interested to know more about that. Who is Harry J. Pierce? He's an executive vice president of General Motors. And are you familiar with a letter that Mr. Pierce wrote on November 24th, 1992 to the Honorable Marion C. Blakely, Administrator to the National Highway Traffic Association? Objection, irrelevant. Let's just hear the answer. Yes or no? Might if I saw it. I can't do it from memory on that date. Yes. Ms. Abramson says, by the way, do you know who? I just want to show that this is this is a certification on the top of that letter. Objection, irrelevant, overruled. The witness says, you're asking me? Objection, calls for speculation. Ms. Abramson says, I am asking if there is a certification at the top of the letter. The court says overrule. Yeah, that's not speculation. The witness says it is a document that has certificate of true copy. Ms. Abramson says yes, from from GM to NHTSA regarding 1973 through 1987 CK pickup trucks, correct, and it was on file in the Technical Reference Division of the National Highway Traffic Safety Administration. Mr. Khan says, I will object to counsel reading. Court says objection sustained. Ms. Abramson said, I am just reading the letter, Your Honor. Court says the remark of counsel reading it is stricken. Ms. Abramson says, may I mark this, Your Honor? Court says 290. Ms. Abramson says, thank you. Now, you have seen this letter before, correct, Dr. McCarthy? Yes, I have. And this letter is, in fact, is it not, an apology from General Motors for submitting objection, calls for hearsay. Man, Mr. Khan does not want this in. Ms. Abramson says, let me finish the question. Mr. Khan says, I'm going to object and ask that we approach. I haven't seen that document. The court says, I'm sorry. Mr. Khan says, I haven't seen this document. I would ask we approach at this time. The court says, let him see the document. There's a pause. Mr. Khan says, I will object to reading of this document on the grounds that it is hearsay and irrelevant, no foundation. The witness was neither recipient nor the sender of that letter. The court says, why don't you show it to the clerk and I will look at it? Ms. Abramson says, while you're doing that, Your Honor, perhaps I will ask some questions. In some of these automobile cases in which you have testified on behalf of the automakers, it's your testimonial function to provide statistics of accident rates for various vehicles. Sometimes. And to analyze the statistics on accident rates for some of these vehicles? Sometimes, yes. And that was a function that you were serving at one time for General Motors, correct? Well, at one time, and still do. And there was a series of litigations, lawsuits, if you will, involving General Motors and some trucks they had where the fuel tank was mounted outside the frame of the vehicle. Objection, irrelevant. Is that true? Objection, irrelevant, 352. Court says, overruled, you may answer the question. The witness says, I have been involved in the regulatory matters associated with CK trucks. Ms. Abramson continues, is that what CK trucks are? The ones where these fuel tanks were mounted outside of the frame? The 73 through 88 models primarily. I can't recollect. I have been involved in individual product suits of those trucks too, as well. Yes. Okay. And were you doing statistical work for General Motors, which was being submitted to the federal government on the issue of the safety of those model trucks? Objection, irrelevant, overruled. You may answer the question. We certainly were doing statistical analysis and preparing reports concerning the relative fire rates of General Motors CK trucks and other pickups. And is the letter that I showed you, does that deal with some statistical material that you submitted to the government on that issue that you just talked about, the fire rates? Objection, irrelevant, and calls for hearsay. Sustained, objection is sustained on grounds of hearsay. That's BS. I think she put enough foundation into, I don't know, whatever. Well, did you submit statistical material on the fire rate to the agency indicated in that letter prior to the date of that letter? Objection calls for hearsay. Overruled. That is not hearsay. The witness says, I never submitted, to the best of my knowledge and belief, anything directly to the agency. All of my reports were forwarded to GM. And is it your understanding that GM forwarded your reports to the agency? Objection calls for speculation, no foundation. Overruled, you may answer the question. The witness says, I gather that they did at some point, yes. And are they apologizing for those reports in that letter? Objection calls for hearsay, no foundation. Sustained, the letter is hearsay. Come on. All this does is infuriate the jury that they don't get to hear what's in the letter. You know what I'm saying? This is annoying. So Ms. Abramson says, let's go back to the beginning of your testimony here. Oh, by the way, Dr. McCarthy, you testified in this courtroom in a hearing before, outside the presence of the jury in October of this year, correct? Yes. And that was on October 2nd and October 3rd? You got me there. Okay. And that was the first time that you displayed these illustrations, as you now call them, the shot sequence, correct? It's the first time I went through this display, yes. And you told us in your testimony over those 2 days that these illustrations had actually been put together within the preceding week before you testified. That's my recollection. And is it true that these illustrations were all put together in the last week in September of 1995? So just recently? Yes. We might have acquired the anthropomorphic models or some other software earlier, but I assembled and finalized these in that last week. So before trial started. Or no. What are we? I don't remember what date we're in. No, I'm blanking. Anyways, well, what you testified to when was that you actually assembled those that weekend before you were here to testify, correct? Yes. I was in that weekend I'm sorry, making these. Right. And that other members of your staff had been loading the program, which then lets you decide the size, I suppose, of the dummies a few days before you actually place the dummies in these drawings and had these green lines drawn, right? And constructing the scene model, yes. So when you say the scene model, you mean the computer model on the scene that's in here. That's correct. Every object has to be, you have to tell it, the computer, every detail of every object or it can't draw it. So you give it all the information and it draws it. That's, yes, simply put. So basically, I think he's just like a CAD person who drew out some diagrams based on whatever stats or data that they used, which may or may not even be accurate. Um, so he says, yes, simply put, it's more complex than that, but yes, that's the long and short of it. We will get back to that complexity in a minute, but I just wanted to indicate that these are something that you made this weekend of September 30th, correct? Finalized. So he just did these. He just finished them. And it took some people some time to put the model material in. They had already input and built the objects and created the rendered surface and stuff like that, which is it's sort of grunt work, but you have to do it to make a final picture. But you place the dummies and place the green lines that are supposed to be the trajectories of fire yourself that weekend. That's correct. However, on July 13th, 1995, you filed a report which describes the sequence of shots. Isn't that true? I filed a report. You got me on that date. Well, I will show it to you. Do you have a copy? I have a copy of it. I just can't do it from memory. I've got it. Hang on. Here, I can. I've got it. Here, July 13th, 1995, correct. On July 13th, 1995, you filed a report, and that report contained the conclusions about the shot sequence that you then, on September 30th and October 1st, put into pictorial form in these exhibits that are before us, correct? Finalized in pictorial form, yes. All right. Before the weekends of September 13th, October 1st, did you have these anthropomorphic dummy forms in your computer so that you could move them around? Not at the time of the report, for sure. I mean, the forms were built prior to my final positioning because that's work that has to be done in preparation. But I believe you previously testified all that building of the forms. Basically, there is a computer program that will allow you to scale these little anthropomorphic dummies, correct? You put in the program and the dummies are in your computer. That's close enough. But you have to scale them and move them, do all that. Yeah. And what you said is close enough. The details is not important. And it was how long before September 30th did you load the program with the dummies into the computer? Oh, people may have been building a week or so before. I don't know. That's a detail that graphics would take care of. Okay, but in any event, your report was at least 2 months before any of the work of loading things, figures into the computer began, correct? Yes. So you never actually sat, and by the way, you made them the weekend before you testified. And then you came in and testified and showed us not exactly these, but a very similar version of these, correct? That's correct. These are a slightly updated version of the previous model, if you will. I wouldn't call them updated, but I'd call them rationalized. Well, you testified at the pretrial hearing that the computer decided the size of the inanimate objects in the room based on its having scanned photographs and being able to scale the furniture from the photographs and from the known dimensions of the room as your engineers had measured it. Is that true? Is that what happened? Very close. The computer shapes the image you're trying to create to look the same as the photographs. In doing so, it backs into various dimensions for various computer components in the picture. I am taking one of these completely arbitrarily, and I'll just turn it so it doesn't block the juror. And I'll ask you, for example, there is this couch representation, correct? Yes. Now, that wasn't drawn by an artist, was it? No, the computer drew every object in that picture. Okay. Now, is there a computer program called couch or furniture or home decorating or something that uses this sort of couch as its standard? There are programs like that, but we didn't make, or we didn't need to make use of it for here. I think we built that couch out of native objects. When you said you built that couch out of native objects, you're not really speaking ordinarily layman's English, are you? I'm sorry. In other words, let me make sure we're clear. You didn't get a furniture guy in with wood and cushions and build a couch up in failure analysis, correct? That's correct. That's correct. So you built it inside the computer. That's correct. Built the image of it inside the computer. This is how far back we were in technology where we didn't understand you had to do things in a computer. And did you use a program, something akin to Image Builder? I am making up a name here, something that can make things if you give it lines and dimensions, etc. We used a program that will make a visible object when given input by the programmer, yes. Okay. And so it is not true that the computer read the photographs and duplicated what it saw on the photographs. In other words, this is not the couch or the type of couch necessarily that was in the Menendez den. Can we answer that one? This is not the same identical couch as was in the Menendez's den. It is not the same identical couch. So the Menendez couch didn't have so wide a back, for example. Do you realize that? I can show you a picture. It's shaped a little differently. It's shaped differently in the back and it doesn't have divided couch cushions, which the Menendez couch does have. That's correct. And the dimension of the cushions may be a little different than the Menendez couch had, vis-a-vis. There's, again, it's just a question of matching it up to the photograph, but there might be a small variation, a half an inch. When you say matching it through the photograph, it didn't match the back of the couch to a photograph. Someone told it to make a back of the couch that looked like the one here in 12B that we're looking at. Yes, so it was programmed in to be the way that it is, which is not identical to the couch. So she's just pointing out the flaws in their diagrams here. He says, yes, but what you do with the computer is you bring the relevant, most important pieces of the photograph of the built image in line with the surfaces of the photograph, and the computer thereby doing backs into a dimension. Word salad. In other words, it's matching the view and whatever dimension it had to ultimately demand to produce that falls out of the program. I'm confused by whatever he just said. All right, but in producing that grand dimension with a little different stylistic detail, is that fair? Absolutely. So basically, this is supposed to show the dimension of the depth of the couch, but whereas the real couch may have more seat or more cushion, this couch has more back. As you indicated, yes. So it went Swedish modern, even though the Menendez couch might have been contemporary. Is that what you're saying? Yes. Objection, argumentative. The court says overruled. The answer will stand. Saberson says, so stylistically, it's different, but size-wise, it's the same? Yes. And did it do the same thing with the coffee table? It could sort of scan the coffee table in photographs and then build it uh, to the best that the building blocks in the computer would allow it. A similar coffee table. Realizing that we didn't get this shot. When you say we didn't get this shot, there is no photograph from the crime scene that reveals precisely this perspective, right? It's overhead and down, so what the computer has to do is look at the perspective. If you look at the table at an angle, there's no square corners, it's off. It's got perspective in it, but the computer understands in its way perspective and backs into it. What does he keep meaning by backs into it? See what I mean by he's just saying, throwing around like terms to confuse people. In other words, it adjusts from the photograph to the perspective you want it to give. You tell it what you want, an overhead shot, correct? No, no, no. And I have confused you. I'm sorry. Don't be so sure. Maybe I am trying to confuse you. But go ahead. You have an angle where the picture was taken and you attempt to match that with the computer and match the appearance. Once the ones are built in the computer doesn't care where you look. So it can move around in all perspectives. All perspectives. And ultimately, when you wanted to memorialize for shot 12B, was this perspective? Yes. But the computer was also built to show these same objects in different perspectives, like 12A, which is this one. I am not using the evidence numbers now because we are just illustrating, but here is basically the same built objects from a different perspective on the computer, correct? Correct. The computer cares not. Now, the first set of these illustrations that you did, though, am I correct in stating it had the furniture was built a little differently size-wise? Yes. And the change that was made in order to produce these illustrations was that based on your finally receiving the measurements that the Beverly Hills Police Department took of these items of furniture. No, it was based on arguing over them. Arguing over them? With whom did you argue? You, ma'am. You argued with me over the size of the furniture? For a couple hours. When was that, Dr. McCarthy? During the preliminary hearing. Do you mean the pretrial hearing? Yes. It was a result of my arguing with you that the furniture was out of scale and you rescaled it? Is that what you're saying? That's pretty explosive. No, instead of getting into a debate whether the scaling of the computer was more accurate than the measurements the police took at the scene, I figured these were differences that made no difference to my opinion, so I just merely brought all the dimensions in line with the police report and then redrew. And when did you redraw them? After the preliminary hearing that following week. So you call it a preliminary hearing, but it wasn't. So it was a pretrial hearing, okay? I'm sorry? Pretrial? I'm sorry. You are correct and I am wrong. Preliminary hearing is a term of art in California and it's not what we did. Okay. All right. So these then are the new versions. Now, did you notice when Dr. Lawrence was testifying that he was using a mixture of the old diagrams and the new diagrams because I gave him some and then Mr. Khan gave him some? I heard you discussing that with him up here, so I guess I would say I became aware of it from your discussions. And were you sitting in the audience through all of Dr. Lawrence's testimony? No, just what I thought was going to be the last morning. Okay, and also sitting in the audience while you were watching and listening to Dr. Lawrence was a gentleman named Don Vincent. Is that correct? Objection, irrelevant, overruled. He came in the afternoon. I don't know that he saw. He may have seen Dr. Lawrence's testimony. I just can't remember. I think he did. Yes, he did. I didn't ask if he saw Dr. Lawrence. I asked if you saw him here. Certainly, Dr. Vincent, most certainly. And he is a friend of yours, right? Objection, overruled. Yes, a longtime personal friend. And it is as a consequence of your longtime personal friendship with him that you volunteered your services to the prosecution in this case. Isn't that true? Close. As a consequence of my friendship with him, I accepted a draft of my services in this case. And he drafted you, didn't he? I was a conscript, yes. Just a poor conscript, is that right? Unfortunately. You understand, do you not, that Don Vincent served as the jury selection consultant for the prosecution in this case? Objection, irrelevant, overruled. I would gather that, although I don't have any specific knowledge of that. He didn't tell you that while he was drafting you to tell you that he, too, was a conscript? Objection, irrelevant, calls for speculation. Sustained. Miss Abramson says, so you volunteered to the prosecution. They didn't come to you. Is that right? I didn't volunteer for anything. Don Vincent called me. Yes, and he said, Roger, if you don't go down there and help these prosecutors convict those Menendez brothers, here's what's going to happen to you. Is that what he said? Oh, no. No? He asked you if you would come down and help out poor old Gil Garcetti, that's the DA, who was having a losing streak, didn't he? Objection, argumentative, sustained. I would ask that counsel be admonished, Your Honor. The court says, well, this is cross-examination overruled. Ms. Amerson says, now, how many criminal defendants have you ever worked for free for, Dr. McCarthy? I don't recollect ever having worked for one. So he's never worked for a criminal defendant? They certainly couldn't afford to pay you, your average criminal defendant, could they? Well, some could, I mean, but it's just not part of the market that my services are used in. In fact, your services have never been used in a criminal case before. Have you or that you have already told us, correct? My services have been utilized in criminal cases before, but I have never testified in one. Well, your services were utilized by television in the O.J. Simpson case, weren't they? Oh boy. That's another flawed case. Okay. They used the same company for the O.J. Simpson case, and we know how that landed with the jury because he was acquitted of all charges and he probably shouldn't have been, but he was nonetheless. So Mr. Khan objected to that. The court sustained it. Ms. Abramson says, oh, did you volunteer to make a videotaped reenactment of the O.J. Simpson case homicides as objection irrelevant? Let me hear the question, says the judge. As a promotional device to gain business for your firm? Objection irrelevant. Overruled. This goes to his credibility. The witness says, absolutely not. I was paid several thousands of dollars to do it. So he was paid for OJ. Okay. Ms. Abramson says, three. As a matter of fact, wasn't it $300,000 to do that? I don't think I got the fee to three, but I would have liked to. Did you get $300,000? I don't think we ended up billing that much for it. It was totally and completely paid for. It was a commercial job. And it was several. You have already indicated it was more than 100,000? Oh, yes, it was a lot of work. And at what rate did you bill to do that? Objection irrelevant to this proceeding. Overruled. We bid that at a fixed rate. So a flat rate? But they ended up wanting a bunch of add-on, and that was all billed at my standard rate of hourly rate of $600 an hour, which is a rate that you feel is lucrative and adequately compensatory for the services, don't you? $600 an hour? I guess I never thought about it. It's the market price. Consulting services is just like everything else. And at the rate, I can't deal with all the demand, but it's better than it would be at $300 an hour. So then you don't think $600 an hour adequately compensates you? Is that what you're saying? It's a bargain rate? It's not a question of compensating me. I am the chief executive officer, so the firm bills the money and takes the revenue. I will characterize the opinion of my board of directors. Well, why don't we try to answer my question about your opinion? With respect to $600 an hour, does working at that rate produce profitability for failure analysis? On my individual hours, I would certainly expect so, but that really isn't the question. The question is that the highest and best use of those hours. So he's not even choosing to answer the question. He's like, the real question is this. Well, in any event, $600 an hour is not chicken feed. Would you agree? It is not chicken feed. I would agree. And for video reenactment of the Simpson homicides was solely for the use of CNET cable television network, correct? Objection. Totally irrelevant to this proceeding. The court says overruled. You can answer the question. The witness says it was to be the premier showpiece of the network launch. CNET network? That's correct. It was not something that was utilized by either the prosecution or the defense in that case, correct? Objection irrelevant. Overruled. That is correct. The work on it started. Ms. Abramson cuts him off and says, you have answered the question. It was not. It was in the middle of the case. And did it air before the case was over? Objection irrelevant. Sustained. So you testified last Wednesday about your participation in a mock trial for the American Bar Association in 1992. Do you remember that? Yes. And this wasn't a real trial, right? That's what it means to be a mock trial. It was not a real one, yes. Nobody's liberty or life was at stake, correct? That is correct. It wasn't commissioned by the government. It was not an official investigation, correct? That is correct. The American Bar Association was using this as an amusement and teaching tool for lawyers, correct? They never pitched the amusement part to me, but they did indicate that they wanted to expose attorneys to scientific and courtroom methods of the 21st century. And again, we were draftees. It was not our idea. And you resisted. Initially, yes. Now you indicated that you were working for the defense, meaning the Lee Harvey Oswald side of that exercise. Is that right? He did the JFK, it was a JFK mock trial. I personally was actually failure provided the experts. So his company provided the experts for both the prosecution and the defense. Right. Is there a fellow who used to work there by the that with you named Pizzali? Pizzali. And what was his first name? Robert. And was he also doing work for the other side, for the pseudo prosecution in that case? Yes. And was the point of that exercise trying to deal with the conspiracy theory of whether or not President Kennedy was shot by more than one person and from more than one direction? No. The point of that exercise was to illustrate the new computer based evidence analysis tools that were available to attorneys and the computer based evidence presentation tools. We chose as the vehicle this trial, and then it was up to the attorneys on each side if assuming their roles as they would have been for the attorneys if the real case had been tried as a murder trial in Texas, Back then, it wasn't a federal offense to shoot the president, so it would have been a state court trial. Then each side was going about the normal things that I gather prosecution and defense attorneys do to play their roles in the murder case. That was a long winded answer about nothing. My question was the side that you were on, the defense of Lee Harvey Oswald side, trying to prove that there had been a shooter on the so called grassy knoll in front of the president. If you can answer that, yes or no, we could move right along. Yes. I mean, they were trying to do more than that, but they were trying to do that too. That was one of the things, and that was the thing for which you fashioned the glycerin bullet, correct? That element of the proof. Now, you testified here that, let me get that transcript for a second. You testified that this thing that you constructed, this glycerin bullet, was basically what a professional assassin would use. Is that right? Yes. So a glycerin bullet is what a professional assassin would use. An explosive bullet is what a professional assassin uses. You can base them on either glycerin and mercury or mercury. In the caliber I was shooting, glycerin was the appropriate choice. Let me read what you testified to. This is 40376. Quote, and I also constructed basically what a professional assassin would use, which is called a glycerin bullet, and that's an explosive bullet. Are all glycerin bullets explosive bullets? Yes. Okay. And you indicated if any of you, I guess talking to us all, ever saw the day of the jackal, it illustrates what an explosive bullet does in that movie. Do you know how the people working on the movie Day of the Jackal put their little special effects together? No, but it was a good illustration of how such a bullet works. And the bullet that was contained in Day of the Jackal, however, it was a mercury-filled bullet, not a glycerin-filled bullet, correct? That's correct, because the shooter was using the .22 caliber and mercury is the appropriate choice for the smaller caliber. And is it your testimony that all mercury bullets are explosive bullets? I can't imagine making a mercury bullet without it. I mean, that is not. Is that yes, Dr. McCarthy? In the way that I am using the term, yes. Well, what I'm asking is the word all, are all mercury filled bullets explosive bullets? I never thought about it, but all the mercury bullets designed that I am familiar with are explosive. That is, they burst using the inertia of the mercury upon impact. And that's what you mean by explosive. They burst. They use the inertia of the internal fluid upon impact with a target to create a pressure or shock wave and increase and dissipate all of their energy in the target as opposed to going through the target. And is that what all glycerin bullets do? In the way I am using the term glycerin bullets, yes, that is. A glycerin bullet is designed never to exit, it's to deliver all of the energy to the target. Well, glycerin melts away inside the human body. Wasn't that one of the points that you were trying to prove at the ABA mock trials? Mr. Khan says, I would object under 352, Your Honor. The witness says, I don't remember. The court says, wait, that's a compound question, so rephrase it. The witness says, sorry. Ms. Amerson says, let's start with this. Was the point you fashioned a glycerin bullet as the supposed weapon of the unknown second assassin for the ABA mock trial, correct? Close. It was a possibility that was not investigated by the Warren Commission. Now, this glycerin bullet was, what is glycerin? It's a clear oil, but you can buy it at the drugstore. I used Walgreens glycerin. And glycerin is lighter than water, is it not? Or do you know? I don't think all types of glycerin are, but the type I was using was. And mercury is not only heavier than water, but heavier than lead, correct? Objection, evidence code, section 352, overruled. The witness says, my recollection is its density is greater than lead, yes, but don't quote that as before. I would opine on that as an expert. I would check, but I think you're right. Ms. Abramson says, now, this glycerin bullet that was supposed to be delivered, this was supposed to have penetrated the head of President Kennedy, correct? Objection, irrelevant. Evidence Code, Section 352. The court says, except that the witness has used this in his own testimony on direct examination and referred to this, so the defense has a right to explore it to some extent. Overruled. The witness says, yes, it would have been the shot directed to the skull of the president. A shot that left no trace inside the skull, correct? It probably left traces, but none that people would look for. None that people saw, correct? Yes. And this glycerin was going to be delivered to the head, was it not? Wrapped in a copper jacket? Yes? Well, yes, that's how I built the bullets, although you wouldn't have to necessarily use that, but I just had copper jacketing, so I used it. You would have to use something to make glycerin penetrate the head because glycerin isn't going to penetrate the head all by itself, is it? Well, you would have, is that yes or no? Or you can answer. No, you're wrong. I'm wrong. Could glycerin, let's break it down. Are you saying you could fashion a glycerin projectile that has no metal sheeting on it that could penetrate the head, pure glycerin? Is that what you're saying? Very close. There is no doubt I could send a slug of pure high velocity fluid into the body at that point. I wished if I get it going fast enough. Yes, with the weapon that was used at the time of the Kennedy assassination. If you were a professional assassin, you would use a weapon of sufficient velocity to penetrate the skull with the fluid. However, since it was using a 9mm rifle, I used a thin copper jacket to hold the glycerin. My question was the weapon involved in the Kennedy assassination, could that have produced a velocity high enough to be able to get a pure glycerin bullet to penetrate the head? That's the question. There is no evidence of a second shooter in the current record. The Kirkano, the Italian carbine being used by Lee Harvey Oswald is not capable of shooting a pure fluid slug. Thank you. That's what she's was trying to get you to say this whole time. You have to encase the glycerin in something to project it out of the uh, ammo or out of the weapon. You can't just put liquid in a gun and expect it to shoot out. It would not go. It would just drip out of the gun, obviously. Now, the one that you fabricated through it was a slug with a copper jacket, right? Yes. And during that ABA presentation, isn't it true that nobody pointed out to you or even questioned you on the issue of what happened to the copper jacket? If your theory was right? Objection, irrelevant. Evidence Code Section 352. Sustained. There was no evidence in President Kennedy's head of a copper jacket, correct? Objection. What is the objection? The court asks. Relevance under 352. Sustained. Now, you testified also on Wednesday. You testified again at page 4371, line 25, that with respect to the test firings for that ABA presentation, that you personally actually fired the weapons for all of those tests. Is that true? For the skull shots I was discussing, I think. Only the skull shots, correct? That's correct. I mean, a lot of other people shot the Carcano for other tests. Yes, Alec Jason, for example, did a lot of the test firing, did he not? He may have. I lent my Carcano to the other side, so. And Dr. Martin Fackler, who also participated in this presentation, he also did some firing, correct? Martin Fackler is a witness for the defense, FYI. He's going to be their first witness. I'll say he blew up my first Kirkano. I don't know if I'm saying that right. I'm not a gun person, so sorry guys if I'm saying that wrong. Are you of a mind to criticize Dr. Fackler at this hearing as opposed to how you lauded him previously? Well, I criticize him for blowing up my Kirkano, but he certainly is a well organized person. Why he wanted to clear a jammed slug with a blank is a mystery. Much of what you've been testifying to is a mystery to him as well. He suggested I ask you these questions. The court says, let's not slip in these things from counsel. Let's just ask the questions. That was inappropriate, but I'm here for it. Ms. Aberson says, isn't Dr. Martin Fackler one of the leading wound ballistic experts in the United States? He is certainly one of those people you would consider for that title. And you have told us you are not a wound ballistics expert, correct? That is correct. By the way, with respect to your ballistics expertise, you testified here that the size of a 38 caliber slug was .380. That's not right, is it? It's not. It's .357? Yes. Your Honor, this would be a good time to take a break. The court says, okay, 9 o'clock is always a good time to take a break. It's 3 o'clock. We will take a break. What? Don't discuss this matter with anyone. Don't form any final opinions. We will resume at 3:20, so they're about to take their afternoon break, and this is where I'm going to leave you for today. We will pick back up with the rest of it tomorrow and probably finish his testimony for this particular day. So, and then we'll move on to the next day. He's still on the stand for a while. We got to listen to this. So, thank you guys so much for watching. Please hit the like button on the way out, and I will see you guys in the next one. Take care. Bye now.